VanGelderen. I am the Business Squad's Legal Eagle, and welcome to my Case of the Week. This is a new series where I'm going to be talking about a recent Supreme Court case, either Michigan or U.S. Supreme Court, explaining a little bit about what happened in the case and why the court did what it did, and then break down how it applies to you and your business, with a specific focus on smaller businesses and Michigan law. Before I get into the actual case, I just want to give a little bit of a disclaimer. When a court makes a decision, they make a decision based on a specific set of facts that are in front of them at the time. And what they do is they use general rules from old cases to apply to this set of facts and then pull it out and make a decision. So what I'm going to be trying to do is pulling out the general rules that the court used to decide this specific set of facts and tell you how you can use those general rules when you're making decisions about your business. But there are always exceptions. There are always a ton of exceptions, and so before you know for sure how a rule would apply to your specific situation, you should give me a call and I'd be happy to talk to you about it before I can help you. So the case this week is Beck versus Park West Galleries Incorporated, and it's a Michigan Supreme Court case. It was actually decided just a couple of months ago. The plaintiffs in this case were 4, 5, 6 different individuals who had gone on cruises. They'd been on cruises, I think, in 03, 04, 07, 08, various times. And while they were on these cruises, they bought different works of art. Probably had a couple too many pina coladas, and they thought that cruise ship art was the way to go. So each time they purchased a piece of art, they were given an invoice, and they signed the invoice, and on the back of the invoice, probably in really tiny print, it had all the different rules that were governing the contract, basically, to purchase it. And in 2003, 2004, they signed one version of the invoice, and the later version of the invoice, in 07 and 08, actually had an arbitration clause. Now what happened is, shock and awe, the plaintiffs found out that the priceless works of art that they had purchased actually had been priced at far less than they were actually worth. Which brings me to my first point that I kind of want to pull out of this, is caveat emptor, except when there's an actual promise, right? So the issue with these cases is that the art came with an explicit certificate of authenticity. It said these are not frauds, these are valuable pieces of art, we promise. And if not, sue us. And so that's what they did, because it turned out it wasn't actually there. So that's something to keep in mind, right? If you've got a certificate of authenticity, right, like I have up here with this Roman coin that my dad got me for my birthday, my dad and my stepmom. So if it turns out that that's just a piece of copper somebody fished out of Lake Michigan, then they can sue them because there's a certificate of authenticity that has an actual promise about what it is. On the other hand, my signed winger drumhead over here from a concert where I actually opened for them, my band opened for them, I was in college, I believe, didn't come with any certificate of authenticity. So if it turns out that's not actually Kip Winger's signature, I'm out of luck. So anyways, something to keep in mind when you're selling something. You got to be very careful about what promises you make and what promises you don't make. So back to the case, right? They sue because the pictures were not actually the pictures they thought they were. And the court said, well, some of them have an arbitration clause, and some of them don't. But you know what, we're just going to throw them all out and say you've got to arbitrate them before you can bring them to court. So that's when the Supreme Court stepped in, and they said, no, that's not quite how it's going to work. So the rules they basically used to make this decision was, the first one, which is the biggest rule, the golden rule of contract law, is that the plain meaning is what the contract says, right? If the contract says something plain, that's what it says. No need to mess around with it. The second thing they said is that in Michigan, when you have separate contracts, they're separate contracts, and you look at each one independently. You don't sort of mash them all together for one big contract. And the third thing is that a contract isn't retroactive. So you sign a contract in 2007, you've actually been doing business for about 3 years with them. That contract in 07 doesn't go back to cover the business that you've been doing. So based on that, the court said, well, we've got these ones in 03 and 04 that don't have an arbitration agreement. In 07 and 08, there is an arbitration agreement. Clearly, in 07 and 08, the parties intended to have arbitration agreements that bound the purchases, right? 03, 04, there was no intent, there's no arbitration clauses. You can't just say that they're all part of the same contract, because that's not how Michigan law works, and you can't apply them retroactively. So some of the breach of contract fraud cases got to go forward, and some of them got dismissed and had to go back to arbitration. So that being said, the 3 quick rules that I want to pull out of this, and we're going to go a little over 5 minutes this week just because I had to do some stuff at the beginning, but I'm really going to shoot for that 5-minute mark going forward. But the 3 takeaways, right? Caveat emptor, except when you make an explicit promise and put something down in writing, right? And say this is an authentic piece of art and put your signature on it. Change in the contract is not going to be retroactive. There are exceptions. For example, if you explicitly put in the contract that this is retroactive, it's going to be retroactive. And the third and probably the most important thing is that the plain meaning of the contract is what the contract means. So if you're looking at a contract and you can't read it, you can't tell what the plain meaning is, probably got an issue there, and you should have whoever wrote it for you or whoever gave it to you clarify exactly what they mean, because otherwise you could end up in court and then the Supreme Court has to decide what it means, and the only people that make money off of that is the attorneys. So you want to be really careful to make sure that your contract just has one clear meaning. That being said, again,